I'm Suzanne, the Steady Coach, and this is part 2 of our series on case analysis. Now, in part 1, we discussed how there's often a situation where in your case papers, you're being asked to do a task where you don't have all the facts, all the evidence, all the information that you might want, and sometimes there's gaps in that information, but that you still got to use a process to try and help you come to a logical, rational decision about how you're going to complete the task or advise your client. Now, in part 2, we're really going to dig a little bit deeper into reading. Now, reading is the foundation to case analysis. And what you're going to do when you get your case papers is you're going to read them once and you're going to find out broadly what happened, when, where, how, who was involved. And you're going to have a great overview of the problem. But then you're going to have to go a little bit deeper, because reading in case analysis is the key to finding out the strengths and weaknesses of your client's case. By finding out where the evidence is corroborated, where the evidence conflicts with the opponent's view, what documents or expert evidence supports your client or undermines your client's case. And in order to find that out, you have to understand the detailed complexities of the case that's being presented. So, on your second reading, it's really important, I think, to start to produce a chronology of events. So you list all the important key things that have happened. And sometimes where it's really complicated and you've got two different versions of a timeline of events, you might have to do two chronologies, one for your client and one for your opponent. And then you've got to work out, where do they agree with timings, where they disagree, where were witnesses, what happened at certain times. You should then be able to identify what all the key facts are. What are the major facts that are important to this case? So if it's a contract case, you're looking to see, was there a contract between the parties? What's the date of the contract? Is it in writing or is it oral? What are the terms of the contract that's important to this dispute? When was money paid by one party for? What were they paying for? What was the service or the goods? What happened about delivery and performance of the contract? These are all the key facts. So produce a diagram or a map or something that helps you to understand how the dispute happened or how the story is unfolding. So, for example, let's say you've got an accident that's taken place in a place of business. For the sake of arguments, somebody was walking along a corridor, they slipped and fell. You need to understand how long the corridor is, where particular in that corridor the person fell, where was a witness standing, how far the liquid on the floor, if there's a liquid, extended on the floor. So it's the detail. If it's a road traffic accident, which lane was the car in? Where was the impact? Where was the other car involved in this incident? Behind, at the back, at the side? Where was impact when the two cars collided? Where were the witnesses in relation to the accident who say that they saw everything? Okay. How fast were the vehicles driving might be indicated in where they stopped after impact. So you need to work out, where were they at the time of the collision, where were they post impact. All of these things, you need to construct a little diagram or some kind of visual record of what it is the parties are saying, so that you clearly understand what happened and how it happened. Okay. I've got all these facts, but what facts are missing? Especially if we're doing a legal opinion, what further facts do I need to make a clearer decision? And you need to be thinking about, okay, I've got all of this evidence, but does the statements or the documents I've read suggest that there's more evidence somewhere else? If it's a road traffic accident, did anyone take a video of the cars after the accident, or a picture? Is there any sort of police collision report? So try to find out what other expert evidence may be necessary, or other documents or witness evidence. And then, so you're asking yourself, have proceedings started? What's the next step? If you're making a submission, at what stage are you in this dispute? And does that influence the application and the submission that you're making to the court? If you're drafting a document, well, is this a document that needs to be drafted? And are there any rules regarding the drafting of that document because of the time or the procedural position that you're in at this stage? All of these things are important that you need to think about. And unless you do this during your case analysis stage, then whatever your task you're being asked to do, whether it's written or oral, it's not going to be as effective. Having read the document, your case papers in detail, you then are going to turn your mind to how you're going to get to that stage of advising your client or doing the task that you've been asked to do. And if you go through things in a logical way, I suggest that there's a structure that you will follow. First of all, having read everything that you've been given, it should be jumping out to you what the legal arguments are in this case. So what is the subject of this case? So if you have a client who's talking to you about, we had an agreement, I bought a car, they said the car was in brilliant condition, now it's not working, I want my money back, then popping into your head should be, oh, this is a contract dispute. Yeah. Now, is it an oral contract? Is it a written contract? Do they have anything in writing that evidences the contract? So by reading what happened, you should be able to work out the area of law that this dispute covers. If you can't work that out from reading the papers, then it tells me that your legal research needs some more attention. So remember that you have to apply the facts, the evidence to the law. Okay, so let's then go on to say you're able to identify the subject of the law that you're dealing with, right? Is it contract? Is it negligence? Is it statutory law? Is it misrep, basically? Those are the main subjects that are going to be covered. So you might actually have more than one potential area of law. So it might be contract and negligence. It might be misrep and contract. It might be negligence and a breach of a statutory duty. So make sure that you can clearly identify the areas of law that you're dealing with. And then once you're able to identify the area of law, your knowledge of law should suggest to you a structure to follow, because we know that in contract law, for example, there are certain things to be established. We know that in order to establish negligence in law, there are certain things that have to be established. And you're just going through your papers when you read the evidence, the documents, to see if all of those points are established to establish that cause of action, or to establish a particular defence, or to enable you to submit to the court that you require a particular order. Okay, so we've got all the main facts, we've identified our area of law, and we know from our legal understanding all the main elements that are required to establish that legal argument. We usually run into a problem, and there inevitably is a problem because no one goes to a barrister because there's not a problem. They go to a barrister for a legal opinion, or to draft a document, or to go to court to get an order because there's a problem. So somewhere in that, the checklist of the things that you need to establish your cause of action or your defence or get your order, there will be an area of weakness or vulnerability. When you find your legal arguments, when you've looked at the weaknesses and you've dealt with those, and you've dealt with the strengths of your client's case, you're going to come to a firm position. So you will draft a document that sets out in law a defence or a particulars of claim, which sets out a cause of action in law as well as on the facts. You will make a submission for an order that the court are able to grant based on the facts and evidence that you've been given based on your client's best case. Or you will provide a legal advice, a legal opinion of the strength and weaknesses of your client's case, the further facts and evidence they require, and you'll tell them what the next procedural steps are necessary. So there's a lot to do, but if you start to approach your case analysis in that logical way, it's far less confusing. And you shouldn't get to the position where you're saying to yourself, oh, I can't do this. I don't know what I think. I'm just going to sit on the fence and not make a decision. That's not the role of a good lawyer. And if you've done your case analysis really well, you will have no problem in coming to a firm conclusion and a logical decision. So that's the second part on reading. Our third part, we're going to look at how we apply our case analysis to certain areas of law. So if you've enjoyed the video, please subscribe. But if you don't want to subscribe, then contact me. You'll see my email address at the bottom of the screen, or contact me on LinkedIn. And if you have any questions about how you should prepare for the bar training course, send them to me and I'll try to answer them. And I may even do a short video if I get enough questions on the same topic. I'm Suzanne, the study coach. It's nice talking to you. Bye.